Every move you make in your own backyard could be sitting on your neighbor's hard drive right now. In most of the United States, they never had to ask your permission. They never had to post a warning sign. And if their camera is mounted high enough, the law says you might not be able to stop them, unless you know the one exception that most homeowners only discover after they've already been watched. The Jackmans lived in Northport, Florida. They were a retired couple who wanted exactly what their backyard promised: privacy. They built a 6-foot solid wood fence. They posted no trespassing signs. They did everything a reasonable person does to say clearly and physically that this space is theirs and no one else's. For the Jackmans, the backyard wasn't a luxury. It was the reason they bought the house. Their lanai, a screened patio attached to the rear of their home, was where they drank coffee in the morning and where their grandchildren played when they visited. The fence wasn't decorative. It was a statement that what happened behind it was nobody's business. Then their neighbors, the Swartzes, mounted a security camera on their roof, not at eye level, 25 feet in the air, with continuous recording and night vision. And they aimed it directly over the Jackmans' fence, capturing real-time footage of the enclosed backyard and the edge of their private lanai. The Jackmans asked them to take it down. The Swartzes refused. So the Jackmans sued. They sued for intrusion upon seclusion, a privacy tort that punishes deliberate prying into someone's private affairs in a way that would offend a reasonable person. The legal standard comes from the Restatement of Torts, the legal reference guide judges use when no specific statute exists, and it has 3 parts. First, the surveillance must be intentional or reckless. Second, it must breach a space where the victim holds a legitimate expectation of privacy. Third, the intrusion must be highly offensive to an ordinary person. What makes this tort especially powerful is that the wrong happens the moment the unconsented viewing occurs. The footage never has to be posted online. It never has to be shared with a third party. It never even has to be watched by the person who recorded it. The intrusion itself is the entire harm. And this same legal standard carries a hidden tool that can force your neighbor to digitally erase your property from their camera's view without you ever touching their device. I'll explain exactly how before this video ends. At trial, the Swartzes argued that because the video stayed stored internally on the device and was never printed or broadcast, no real damage had been done. The trial court agreed and denied the Jackmans' request for an injunction. The Jackmans appealed. The Florida 2nd District Court of Appeal unanimously reversed the decision. The appellate court handed down 3 rules that now govern neighbor camera disputes across the state. Publication is irrelevant. The intrusion is the harm. A solid privacy fence creates a legally protected expectation of privacy, and the physical placement of the camera, specifically elevated to peer over that barrier into an otherwise unobservable space, is the deciding factor. The court certified the question to the Florida Supreme Court, recognizing that the outcome would affect millions of homeowners navigating the same technology. But Florida was not alone. In North Carolina, the Court of Appeals reached the same conclusion in Nichols versus Calhoun. Neighboring property owners in Pender County had been locked in a boundary dispute. After a new fence went up, one side installed a Wi-Fi-enabled smart camera with motion detection and real-time streaming. They mounted it on their property, but pointed it directly over the fence, capturing continuous motion-activated footage of the other family's backyard. The camera owners moved for a directed verdict, asking the judge to rule that standard home security cameras cannot create tort liability as a matter of law. The trial court denied the motion, sent the claim to a jury, and the jury found the camera owners liable for invasion of privacy. The North Carolina Court of Appeals affirmed, when a camera is installed amid an active dispute and deliberately aimed over a fence into a neighbor's primary outdoor living space, a reasonable jury can find the intrusion highly offensive. So how does a judge tell the difference between a legitimate security camera and an illegal privacy invasion? They look at 4 specific factors. Height and angle matter enormously. A ground-level camera, capturing what any passerby could see over a 4-foot fence, is rarely a problem. A roof-mounted device on a 25-foot pole designed to look over a 6-foot privacy wall becomes an unlawful optical periscope. The law cares about whether the technology defeats barriers you built to be left alone. Focal length and technological enhancement raise the stakes. Pan-tilt-zoom features, powerful magnification, or infrared night vision that reveal details inside dark windows receive heightened judicial scrutiny. A camera that can read the title of a book in your living room from across the yard is not the same as one that shows a blurry silhouette. Duration and continuity change the legal character. A fleeting glance from a second-story window is casual observation. A 24-hour archived recording stream that catalogs every movement, every visitor, and every hour you spend outside is a systematic accumulation of data that courts treat as a qualitative invasion. A person might look once. A machine never blinks. Finally, context and intent influence the outcome. When cameras go up during an active boundary fight or documented harassment campaign, judges are far less likely to accept the defense of simple property protection. A security camera installed the day after a fence argument looks less like protection and more like a weapon. The legal system has now devoted multiple appellate opinions to determining exactly how many feet of elevation turn a security camera into a privacy violation. Suburban America at its most efficient. But the legal weapon almost nobody talks about has nothing to do with the camera's height or angle. It has to do with a mistake most homeowners make the moment they discover they're being watched. They forget about audio. The Federal Wiretap Act allows recording as long as one party consents, but state laws diverge sharply. In all-party consent states, like Massachusetts, Florida, and California, a smart camera equipped with a sensitive microphone that captures private conversations on an adjoining property without permission violates state eavesdropping statutes. It does not matter that the camera sits on your own roof. If the microphone picks up your neighbor's voice in their own backyard, you may have committed a crime. Disabling audio recording eliminates the wiretap risk, but it provides no defense against visual intrusion upon seclusion. Optical invasion into a private space is fully actionable on its own. The practical reality is that this problem is growing faster than the law can adapt. 30% of American internet households now own a smart camera or video doorbell. Over 15 million households, roughly the combined population of New York, Los Angeles, and Chicago, rely exclusively on standalone smart cameras for security. The average owning household deploys more than 2 video capture devices. With that many lenses along suburban property lines, overlapping fields of view are not an accident. They are a statistical certainty. So, what do you do if you find a camera aimed at your bedroom window or your enclosed patio? Start with evidence. Photograph the camera's exact location, mounting height, lens angle, and field of view. Document whether the infrared illuminator activates at night. Measure the line of sight from your private spaces to prove direct targeting. Keep a log of dates and times when you observe the camera's position or notice its indicator lights. Evidence wins these cases, and most homeowners who lose do so because they walked into court with complaints instead of proof. Then send a formal demand letter by certified mail with return receipt requested. Cite your state's intrusion upon seclusion standard, point to Jackman or Nichols if you're in Florida or North Carolina, and formally request that the neighbor re-angle the device, lower the mount, or apply a software privacy mask. Most modern cameras allow the owner to draw a digital blackout zone that blocks your property from the lens entirely. That single setting can neutralize the camera without touching a single screw. It is the cleanest resolution available, And judges love it because it solves the problem without ordering anyone to tear hardware off their house. If the neighbor refuses, and you live under a homeowners association, file a formal grievance citing nuisance covenants or architectural control rules. Many association agreements prohibit exterior fixtures that disrupt peaceful enjoyment, or require architectural approval for any mount visible from the street. An HOA can often force a repositioning faster than a court can. If administrative remedies fail, file a civil complaint in state court alleging intrusion upon seclusion and seeking a preliminary injunction, a court order that forces the neighbor to stop recording while the case proceeds. Most judges will issue that order before the full trial begins, especially if you have already erected physical privacy barriers that the camera was clearly designed to defeat. The law rewards homeowners who build fences and post signs because those barriers prove they expected privacy. The distinction courts draw is simple but precise. You have an absolute right to secure your own property. You do not have a right to use elevation, zoom, or continuous archiving to defeat the physical privacy barriers your neighbor built on theirs. A privacy fence is not a challenge. It is a legal boundary that technology does not override. Next time, we're looking at the homeowners association fine that can cost you your house. Not thousands of dollars, not hundreds. $50. One unpaid grass violation. And the legal precedent that lets them take the keys.